Welcome to Estate Planning Beyond the Binder.
Hey there, and welcome back to Estate Planning Beyond the Binder with Brian Chu, managing partner at OC Wills and Trusts and a leading estate planning attorney serving Orange County families for over 25 years. I'm Kevin Rosenquist, and in this episode, Brian explains why putting your kids on titles can trigger tax issues, creditor risks, and family conflict, and what safer, smarter alternatives you might consider instead. Brian, welcome back.
Thank you, Kevin. Thank you for having me on today.
So why do so many people add their children to the title of their home, and what are they doing that for? What's the purpose?
Usually it's the parents are getting older, the kids are adults, and they want to avoid probate, especially here in California, because probate's very expensive, time consuming. And so one of the ways you can avoid probate is to put your kids on title, usually as a joint tenant, which means, let's say you have two kids and it's two parents, all four people would be on title and they would all effectively own 25% of the property. Something happens to both parents, the two kids will get, if the two kids are living, they will then own the property 50-50. It's all automatic. There's a little bit of paperwork to file, but they would then own the property. There's no probate. Thus, they've now saved them the cost of doing probate, which can be in the tens of thousands of dollars. However, there's a lot of downsides to doing that. And so, yes, that's the quick and inexpensive way to do it, at least for now. That's the quick and inexpensive way to do it. But that can cause problems, tax issues for the kids down the road, especially here in California. And we have two big tax issues in California. We have property tax issues and we have income tax issues. Okay. And putting the kids on title can have an effect on both.
Yeah, I honestly I've never even really heard of people doing that before. Is it a common thing?
It's not uncommon.
Okay.
We see it, we see this happen. And the issue now is fixing it can be a problem. And it used to be before what's called out here in California, we have what's called Prop 19. Before Prop 19, when we saw this, we could fix it. We just take the kids off title. The kids give the property back to the parents put in a trust, and the kids will inherit the property one day. But now, it's harder to fix now because of certain property tax laws potentially that might be in play. But yes, I wouldn't say it's common, but it's definitely not uncommon either. But again, because people read that that's an easy way to avoid probate, not realizing there's potential tax consequences for the kids. And also, as you mentioned, there's also asset protection issues that are brought up because of the kids.
Would you say that's the biggest misconception about this, about doing this, is that people think it'll avoid probate?
I mean, that's not the misconception. It will avoid probate. It will avoid probate as long as somebody's alive.
Right.
Okay. Now, especially if we have circumstances where, there's parents or, we're, a parent and one child, or one parent and one child, and that child is driving the parent around. That creates the problem with just having individuals on title is that there is the possibility, especially all those people in a car together, and that's why we do planning for, parents even, obviously, is because something could happen to both of them. Is if something did happen to everybody, that would go to probate. Now, as long as somebody's alive, it doesn't go to probate. So that's the issue. It does avoid probate as long as things kind of happen as we expect them to happen. But if things happen unexpectedly, which again, and I always tell people, the most risky thing we do every day is get in a car and go somewhere. And then the question is, who are we in the car with? And I always assume everybody can pass away. Especially here in Southern California, we see it happen every day. It's not getting on a plane, going on a trip. That's 100 times safer than you getting in the car. And that's from any number of things. Also, we talk about the liability issues, with your kids. Probably the biggest risk of putting your kids on title, is that now you are risking the property to your children's creditors. Okay. If you put them on title, something happens to them, they get in a car accident, they get sued, whatever it is, maybe divorce, again, it kind of depends. That asset could be lost or be subject to somebody else's claim. And now you've lost a property for something that if your kids contribute to the property, fine, they should be on title. Okay. If they help you buy it, whatever they're, you're investing with them, they should be on title. But if you're just putting them on for convenience, that's putting a risk an additional risk on the property that doesn't need to be there. And that's probably the number one reason why it's a bad idea to put the kids on title. The second reason not to put kids on title is because of what we call the step up in basis. Okay. For better or worse, when somebody dies, because most of us don't have enough money to be worried about the estate tax, which is currently $14 million per person, $15 million next year. when somebody dies, dying for better or worse is the great tax eliminator. As much as people think you pay tax when somebody dies, it's actually the other way around. For 99% of us, dying is actually saving somebody money for the most part. Because when you pass away or you inherit assets, and it doesn't matter whether it's a trust, it can be anyway, joint tenancy, whatever it is. When you inherit an asset from somebody, you get what's called a step up in basis. Okay, basis is what the IRS considers you pay for something. As an example, let's say you own a stock, it's worth $100. Okay, and then it goes up in value, it's now worth $300. If you were to sell it while you're alive, you pay a tax, right? You pay a $300 minus $100, the basis. I made a $200 profit. I pay a capital gains tax on the $200 that I made. Okay. However, if I pass on, if I hold that stock and then pass on, and then that stock goes to my son, his basis becomes $300 in that property. He gets a step up from $100 to $300. He sells it for $300. He pays zero capital gains tax. Okay. That's because he inherited the asset from me. I owned it. It went from me to him. And whatever he got from me, he gets a step up in basis. Okay.
Okay.
Now, and that would be the same thing for a house. And we have a lot of people, especially in California, they paid $50,000 for the house. It's now worth $500,000. Okay. And so if my kids inherit that house from me, they sell it for that $500,000, they pay zero capital gains tax. Okay. Now, and then moving forward, if they do sell the house, and this is a good thing, let's say the house goes up to $600,000 when they sell it. Now they're only paying tax of $600 minus $500 because my passing established a new basis in the property. Okay, but they only get that if they inherited the property from me because I owned it when I died. However, if I put them on title now, so again, myself and my son, if I put them on title as a joint tenant, I have to do it 50-50 because anything, if it's not joint tenancy, it's then tenants in common, which is subject to probate. But joint tenancy means if I die, either one of us dies, the survivor gets it. Okay, if I die and he gets the property, he now owns, he got my 50%. But he already owned 50%, which means he only gets a tax break in half the property. Okay, so again, under that scenario, let's pay $100,000 for a property that's now worth $500. Okay, if he gets it from me, just 100% from me, he sells for $500, pays zero tax. If he already owns half, which means he now effectively owns half the property, only half the gain gets eliminated. So in this case, the gain was $400,000. $200,000 of the gain will go away because he inherited that $200,000 from me. But that $200,000 profit he had on his side, he pays a tax on that if he sells the property. Obviously, if he doesn't sell the property, then it's less of an issue. But if he sells the property, the basis, his share of the basis in the property is always going to be half of what mine was when I bought it. So and so that never goes away. And so he will never get that tax break on the part he already owns because I gifted to him while I was alive. Okay.
Okay.
And so that's the number one issue, especially here in California, why it's usually beyond the, exposing the assets to your kids' creditors is the potential loss in a tax break for your kids for usually no good reason.
How old does a kid need to be before you can put them on there?
They have to be 18.
18. Okay.
In order to own anything, you can't own, if you're under 18, you can't own a pack of gum, let alone property. Okay. Now, obviously our trust, though, it's going to be set up so that, regardless of what age my kids are, the trust can own the property on their behalf if they're under 18. Even if the kids are under 18, we solve that problem through the revocable trust that somebody else will be in charge of it other than the kids.
So if someone comes to you and tells you that they want to do this, that they want to put that they did it, or that they're planning to do it or something like that, what do you tell them is the better option? Where do you try to steer them?
Well, as I just mentioned, usually we're steering them towards a revocable living trust.
Okay.
Putting the asset into the trust so that the kids will inherit it one day. So and it makes it simple. The property's not exposed. The parents are in complete control of the property. It's their property. They do whatever we want with it. Because obviously the other issue is if you put your kids on title, if you decide you want to do something with it, refinance it or sell it, you got to get the kids' cooperation. Mm-hmm. And they may or may not cooperate. Or here's the other issue, and this kind of get off topic a little bit, but once you kids are on title, they can now force the sale. If your relationship with your child changes, and again, this is irrevocable. I mean, the kids can always give the property back in theory, but once you give the property to the kids, you can't change your mind about it. Okay, a relationship changes, whatever, you can't change your mind about it. And then worse yet, the relationship, it's not even that you can't change your mind about it. If the relationship goes bad, as a owner, whether it be any owner of a property that's jointly owned, they can force the sale of the property. Okay, they can go, and if you don't cooperate, they can take you to court, and the court will force you to sell the property. All right, so
Mhm.
you lose all kinds of control with the property. So that's the number one issue. Versus you put in the trust, you have complete control. You can change about things. Anything regarding your relationship with your kids change. Your kids have no say. While you're alive and well, your kids have no say. It's your property. And then so no control is lost. There's nothing exposed. And then B, when the kids inherit the property one day, they get the maximum tax break in terms of the step up in basis.
Are there other reasons people do this than other than oh, it's just it's easy, it's cheap, and all that? What are people thinking when they do this, rather than going the more traditional route of going with a trust or something like that?
I mean, the most common reason why we see it otherwise, and again, we wouldn't necessarily recommend that we might recommend they put their interest into the trust, but it's because the kids helped. The
Yeah.
kids are involved in the property.
Right.
But and I just had a client come in just right before you session today, and that's the exact situation. They put the kids on title, and now they're trying to figure out what are the consequences of doing so, especially if it's if I for my share, if I depending on who's on title, I may have wanted my interest to go to somebody other than that child, maybe because it was money that, especially if I have multiple children, I might have helped one of the kids buy the property or something like that, but I still retain an interest in the property. I might want my interest to go to all of my children, not just to that child. Under a joint tenancy, obviously, it would go to that one child, and sometimes they don't realize that their share would go that way. And so that's when we're recommending even to sever the joint tenancy, even if they don't want their interest to go to those children that are on title, or that person, if they want to go to other people, then they need to put their share into their own trust at that point.
What if someone has already added their child to the title and they're really second guessing that decision? What's the best course of action?
It depends. Unfortunately, here in California, as I mentioned before, we have some property tax laws that, depending on the circumstances of who acquired title and who was on title originally, that giving the property back, you only have options if the child's cooperating. Okay, because again, if the child doesn't want to cooperate with you and doesn't want to give the property back, they don't have to give it back to you. You already gave it to them. They're on title. You can't change that. The best you can do is, if you don't want them to get whatever percentage you own, you can change that. Okay, but the percentage you already gave them, you can't change that on your own. But even if the kids want to give the property back, there's a lot of different issues now because of property taxes. It's all depending on what happens, what the plan is, at least tentatively, when that person passes. Are they going to sell the property? Going to keep the property? And so there may be some arguments. If they're going to keep the property, maybe it is worth keeping it in the trust. Keeping it in joint tenancy, because there may be some property tax benefits if they're going to keep the property. Okay, but if they're going to sell the property, probably are better off getting the property, maybe giving the property interest back to the parents and then inheriting the property so they get the tax break. But depending on the circumstance, that might trigger a reassessment of the property, and that might be so. It's not an easy, and we're confronted with that somewhat often. A lot of times I'll tell my clients, I'll give you the best advice I can, but at some point somebody's giving up rights, and so somebody needs to talk to an attorney about that.
Right.
Understand the tax implications of doing so. Understand both the income tax and or property tax implications. Because there are anytime you give up ownership of something to somebody else, and again, when you put your interest into a revocable trust, nothing's changing. So you're not giving up any rights, no interest, nothing changes tax wise. But when you give something back to or you put somebody on title, or you give somebody take your name off title, you're giving something to somebody, and there is a potential tax consequence. Maybe there's none, but it depends on the circumstances. So that's why we always tell our clients, you may want to talk to your CPA or real estate attorney about this before making any decisions. So, and hopefully that was unfortunately, they may or may not have done that when they made the decision to put them on title in the first place. They may have decided, they didn't get any advice. They did a quick claim deed and put the kids on title. But hopefully this time around, they'll consult who they need to consult with to make sure they understand the consequences of their decisions. And in the case, the problem with these consequences is they are permanent. Giving the property back, taking somebody off title to fix it, or putting somebody on title. That's the way they do it. It is a permanent decision that you by yourself can't change. Versus doing a revocable trust, you have complete flexibility control over that.
Yeah, it feels like there's really no downside to going the revocable trust way over the joint ownership way. It's just from what you're saying, what I'm gathering from it.
Other than that, it's more expensive to do. Other than that, yeah, there's no downside for doing the revocable trust in terms of if your primary goal is to give the property, is for you to enjoy the property while you're alive, 100%, and then it goes to your kids at your passing. And so, assuming that's what you want, then yeah, a revocable trust usually is the best course of action.
Yeah, that's certainly what it sounds like from my view. So, all right. Well, thanks for tuning into today's episode of Estate Planning Beyond the Binder. Brian and the team over at OC Wills and Trusts can be reached through their website at ocwillsandtrusts.com or give them a call to schedule a consultation. Thanks for listening today. Be sure to subscribe to our channel. Leave us a review. We greatly appreciate it. Brian, always great chatting with you. Thanks so much for being here.
Thank you, Kevin. Have a great day.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.